Student loan debt has a special status in bankruptcy law. It's one of the most difficult categories of debt to discharge. Both federal and most private student loans are non-dischargeable, absent a showing of undue hardship, a standard that has historically been interpreted extremely strictly by bankruptcy courts. Here's a comprehensive overview of student loan bankruptcy treatment for both creditors and borrowers. The statutory framework, Section 523A(8) of the Bankruptcy Code, accepts from discharge any educational loan, federal or private, made, insured, or guaranteed by a governmental unit, or made under a program funded by a governmental unit or nonprofit institution, or any qualified education loan as defined in the tax code. This covers virtually all student loans taken for attendance at accredited institutions. The undue hardship standard. To discharge student loans in bankruptcy, the debtor must file an adversary proceeding, a separate lawsuit within the bankruptcy case, and prove undue hardship. The most widely used test is the Brunner test, which requires first that the debtor cannot maintain, based on current income and expenses, a minimal standard of living if forced to repay the loan. Second, that additional circumstances exist indicating this state of affairs is likely to persist for a significant portion of the repayment period. And third, that the debtor has made good faith efforts to repay the loans. Recent Department of Justice guidance. In 2022, the DOJ issued new guidance to its attorneys handling federal student loan undue hardship cases, signaling a more favorable approach to settlement and discharge in appropriate circumstances. Some bankruptcy courts have begun applying a totality of the circumstances test that is somewhat more flexible than the strict Brunner test. For creditors, typically the Department of Education or private lenders, the non-dischargeability of student loans provides strong protection. However, the DOJ guidance has opened the door to negotiated resolutions in hardship cases. Understanding the current landscape helps creditors manage exposure in cases where debtors are genuinely pursuing undue hardship claims. Income-driven repayment as an alternative. Even when discharge is unavailable, income-driven repayment plans under federal loan programs may provide effective relief to struggling borrowers without requiring bankruptcy, which has implications for default rates and collection strategy. People Locator, skip tracing assists student loan creditors in locating borrowers who have defaulted and gone dark. Visit peoplelocatorskiptracing.com to place your order.